Hi, and welcome to another edition of the Trustcast Show. And we're really happy to have with us this morning Kyle Moore, a real patriot. Thanks for coming on the show, Kyle.
You're so welcome. Thanks for having me.
So, Kyle was in the first wave of Marines to invade Iraq, then spent 13 years in courtrooms fighting insurance companies, and now is one of only a few hundred attorneys in America authorized to sue the federal government on behalf of people hurt by vaccines. Kyle, you enlisted 1 week after graduating high school. What was going through your life at 18 that made you feel like that was the right call?
Um, Quite frankly, just being able to support myself, to be on my own in life, I was very ready to leave home and establish myself. I was actually 17. I turned 18 in boot camp, but my primary motivation was to learn a trade that would serve me in a job in the future and sort of that traditional recruiter pitch at the time, money for college, a steady job, a way to go out and basically. Yeah, that's what I was
Well, it
thinking
seemed
at
like
the
it.
time.
So did that. So then you ended up, storming the beaches at Normandy, so to speak.
Yeah, that was a curveball, as you might imagine. I I joined before 9/11, so when I got home from boot camp, 9/11 happened. It's just I'd been newly minted a Marine, and so everything changed. We then began really high tempo uh, training and preparations throughout the entire Marine Corps, and yeah, I ended up in the invasion, learning all kinds of skills, as you might imagine, most of which were not transferable to the civilian world.
Hmm.
But it was definitely something that I thought only existed for, uh, really hardcore infantrymen and frontline operators, things like that. But what I really learned was that it takes a lot of different skill sets to successfully invade a country or to maneuver a major military operation. It was a very eye-opening experience. So I'm glad about it. But definitely was not something that, as an engineer, that's what I was trained to do in the Marine Corps. I did not think that I would be as high speed as I ended up being in my life. Yeah.
Yeah, engineers. My dad was an engineer in World War II and the Korean War, and he was right in the thick of it.
Yeah, I honestly thought that I would be, a support element and would maybe be in some challenging circumstances. But what my unit ended up doing in the invasion was something called forward arming refueling points. The type of engineer that I was a fuel engineer, and my particular assignment was to make sure that attack helicopters had plenty of aviation fuel 24 hours a day during the entire ground campaign in the invasion. So I was maneuvering with a 5,000-gallon jet fuel tanker, providing our own security, and we had what's called a provisional rifle platoon made up of other engineers, and we sort of did this leapfrogging mission where we met attack helicopters all over the theater, southern Iraq, all the way to Baghdad, and provided them with real time aviation support, gas, bombs, things like that. And it was very interesting.
Yeah. So I saw in here. It's not my questions, but we did do a lot of research. You were also an Eagle Scout, is that right?
That is true. Yes. I started scouting as a teenager, kind of got into it late, and just had the great fortune of being near a really great troop in Tampa, Florida, Troop 4, and they had a very active adult leadership community. So there were many opportunities for hiking and excursions, going out to the Philmont Scout Ranch, doing some pretty extreme trips on the Appalachian Trail, 10, 20 mile a day as a 14, 15-year-old. It was really fun. And it gave me a lot of preparation for the Marine Corps. But what really pushed me over the edge from getting to my last rank of Eagle was my recruiter told me that they would give me a rank in the Marine Corps if I finished. So instead of going in as a private, I went in as a private first class, which gave me just a little bit of bump in pay and leadership. And so I went ahead and finished all the requirements for Eagle, and got that extra bump when I joined the Marine Corps. That was the real kicker for me, and it served well.
So yeah, so if anybody doesn't know about the Boy Scouts and becoming an Eagle Scout, it's quite an accomplishment. Um, so
Thank
let me switch gears because we're going to talk about your practice and what you do. I have on here trial attorney and trial consultant.
Yes.
So you spend a lot of your time with car accident victims or truck accident victims. So let's say I was just in a car accident and the other driver's insurance is already calling me. What's the first thing I ought to do?
Well, the standard of care basically, and on the plaintiff side would be to say, not to trust that when you give statements to insurance companies that they have your best interests in mind. I
But they say they do.
That's true, and I believe that the training that adjusters receive is adequate in that basically they're only supposed to pay what is owed and not a penny more, not a penny less. And I think it gets a little gray when you start talking about what's owed. And at the first notice of loss, it's really difficult to tell what's owed. And because injuries and symptoms don't present immediately and can take some time. So if you say something like, "Oh, I feel okay, my back's bothering me a little bit," that might get logged inside of an insurer's system as something that's low severity, when in reality, it's could potentially turn into something much more. So I think that for me personally, it's not an undoable fact that someone gives a statement or makes a comment that might hurt their case, from a adjuster's perspective when they're adjusting the claim. And for better or for worse, I think adjusters are just trying to do a good job, and that means they serve a duty to their insured and the insurance company. It's a tri-part duty that they owe, which is difficult to juggle. So I get it, but I would generally say, hey, just be careful with what you say. That injuries do creep up. It takes time for you to understand what's fully going on, and if you do make a statement that might be detrimental to your case, I might have to do a little bit more finagling if I'm representing you later to get that case to another adjuster to have a different review, or maybe go into litigation and like actually develop some evidence that can be used to leverage against what, might ultimately be not true, what you said after you first had the accident versus what really happened to you, 2, 3 months later.
So are you better off if it's the other insurance company just to not talk to them and go to an
I
attorney?
mean,
Let's say if you're injured or
I think it depends on what's really wrong with you, and I've seen so many different types of injuries and types of cases. I do believe that some folks don't need an attorney and that some adjuster and unrepresented client relationships can resolve in a mutually beneficial way. But, if I'm giving general advice, I would say that it would be good for someone to talk to an attorney maybe, or to do some research about what might happen when they make that first call to the at fault driver's insurance, or to any insurance company for that matter, just because there are some limitations that adjusters have in what they can and can't do. And it's it it might be a difficult situation for the client later. So I'd say just be careful. And it really depends. I try not to cast a broad stroke against all insurers or all adjusters. I don't think that would be fair. But there are definitely some bad apples, just like there are on the legal side too. So I would say just, be careful.
do you think it's usually the adjuster or the insurance company that is being persnickety? Are there some insurance companies that are more like difficult to work with than others?
Yeah, I think so for sure. There are lots of different types of insurance products out there too, different types of companies. in commercial lines, for example, there are these insurance companies that are called risk retention groups. And if you look at insurance regulation generally, any mechanism that transfers risk from one place to another could be considered an insurance company. So, yeah, the way they treat claims is different. And I think most persnickety outcomes or lowballing type situations come more from a leadership culture within a particular claims department than they do from like a top down approach at the C-suite level of, like a major headquarters of a big carrier. There's just so much risk involved in the regulation of the industry. So I think, while the training an adjuster might go through might cause them to say, hey, it's right to pay fairly on a claim, they might have a boss or some leadership structure who's seen a lot of fraud, encountered a lot of cases where lawyers were asking for too much and living with these wild expectations, and they might have a bent of mind. I think that that's probably more the case with lowballing, is that it's not a systemic rule that folks have to follow. It's more a bent of mind of a particular region or a team of claims people and the leadership that they're in. Yeah, I think it's more of a cultural problem, honestly.
So I know one person that I know is an insurance agent, and he makes money on the basis of part of the money that he makes is on the basis of how many claims get paid out that he's written. So, do the insurance agents get involved at all in the process? Or-
Yeah, but mostly from my experience, insurance agents are like the first place people call when something
Mhm.
happens. It's whoever they got their policy from. And candidly, I don't have much interaction with those people. I'm starting to learn more about their business by another software product that I'm working on that deals with personal injury work. But um, I think that brokers, agents, the people who sell those policies to the actual consumer, the handshake deal, that, there's still a lot of that happening, especially in rural areas like in Georgia. And that's the first place people call. Now, do those people who are agents and who are selling policies and who take that first call, do they have the kind of bent of mind that maybe an unfair adjuster has? Do they have some other incentive mode? Do they have none? I don't know enough about some of those responsibilities that they have, but I think it is a it's important, I think, for there to be education at that level about, you know, what a real personal injury case is. Uh, and it's, I hope, not an opportunity to take advantage of someone, but an opportunity to do what the contract requires, which is to thoroughly protect the insured and pay on meritful claims up to the limits of coverage in exchange for protecting the insured's assets. I think that we get lost, agents, adjusters, and others, the lawyers too. We get lost in the adversarial nature of the process and it becomes very us versus them. But at the core of this is just a simple contract, a promise that's been made, a duty that's triggered upon a certain action. It's really unemotional when you look at it from that perspective. But, we have some really highly charged breaks to look at. We have some very well-resourced tort reform efforts happening right all the time. So, there's a lot of people joining into different camps. Agents might be some of those people in that process. Yeah.
So I saw on somewhere on your site, you had somebody who a police report um, didn't put anybody at fault, but you were able to exercise an outcome. Can you talk about that idea where the police comes and say, "I don't know who's at fault, whatever,"
Yeah.
and
That
how do
happens
you deal with that?
frequently. Yeah, that happens frequently. As an aside, I sort of made my practice out of taking scraps and dog cases from other people, other lawyers, and turning them into something. These police reports where no one's at fault, uh, generally speaking, litigation is the most effective way for me to develop real evidence that creates leverage. So while a police officer's narrative and their report is an admissible document, you also have to account for the fact that it's hearsay and you need to present the witness, the officer, to talk about what was said in that document. So just having a report where there's no conclusion being made is one way to look at what happened in terms of liability. But then when you add in taking the officer's deposition, asking him questions about why he didn't make a conclusion, sometimes it's I didn't get the chance to talk to someone because they were in an ambulance and then I never got a chance to follow up. And I couldn't make a determination until I talked to them. Well, that changes the calculus once you have both of those pieces of evidence together. But, if I'm an adjuster, maybe I'm in my first 5 years, I'm doing good at my job. I see a police report where no one's at fault. I don't look any deeper in
Hmm.
making a conclusion on liability. It requires this extra analysis, this extra step of bringing in testimony. Testimony is some of the most powerful evidence there is. Jurors, I think, like documents, but a jury is not going to read 1,000 pages of medical records, but they'll pay attention to the first 5 minutes of someone's testimony, especially if they're wearing a badge and a gun on their hip. Very powerful presence.
So
So,
how do you get the information out of a police officer that you want that maybe he doesn't want to give without being that deleterious to his testimony? So that you're like coaxing it out of him. He doesn't really want to give it, but how do you massage that? As you smile there,
yeah,
because that's must have
it's
touched a nerve.
it's delicate. I smile because this is where the real magic of the practice happens. This is what I like the most about litigation is getting to the people that are involved in the story. Every police report is one of the first few pages of the story that a jury is told. And the way I've been trained to do this practice is to work every case as if a jury is going to decide the outcome, period. There's no exceptions. I don't take a case unless I'm willing to take it to a jury. Well, jury trials are all about storytelling, so we start with characters. Okay. Sometimes a character who's withholding, who doesn't want to come along when you pull the rattle, that can actually look better in terms of the value to the client when you look at the whole story in context. So if I have an unruly law enforcement officer, I'm certainly not going to try to outsmart them, because it doesn't require a JD to become a law enforcement officer, but they have a lot of power. The same
Hmm.
way I wouldn't try to outsmart a physician and say, well, I read this study that says such and such, and you weren't on that paper. So, very easy way to backfire getting something that's effective for your client. So, if I had an unruly officer who didn't want to conclude one way or the other, then I would just solidify that that's what his opinion was so that he couldn't go anywhere else with it. And then I would try somehow to create likability between him and I. Usually that starts with a couple phone calls that I have before he shows up for a deposition. They'll want to know why, they'll want to know what they can do to prepare. And in those conversations, number one thing, saving time. I'm not going to waste your time. I'm not going to ask you questions that aren't relevant and don't matter. We're going to be done in 20 minutes. You know, I'm looking for 2 or 3 sound bites that I can tell a jury about what we can and can't conclude from your report. Very neutral, very objective, very calm, very law enforcement. These guys are trained to try and have emotion, listen to how they talk. The perpetrator appeared at the corner of Maine. And so, you have to, I think, communicate on their level and realize that what you can get that may be helpful to your case might just be 1 or 2 sentences. You can't take hours to do that. You just need to really prepare early on. What type of questions? What is it that will help the case in the context of the whole story? And how can I make this guy feel good about this? Because The deposition is just one thing. If the defense raises the evidentiary issue of needing the witness to come live because that's more credible and that's a better source of evidence, well, now you got two appearances this guy has to make.
Mm-hmm.
So if he doesn't like you, now he has to show up in court for you. If he doesn't, we got to subpoena him. You don't want to be in a situation like that. You want people in your story to want to help. And I think when you approach a law enforcement officer with just, hey, now we have some more information. Now you're here to tell us one way or the other, what's going on with your report. We're going to stand by what you say. We're not here to make you out to be a liar or to change what you're saying. You really, I think, have to support them in whatever the evidence is. And it's not my job to manipulate evidence. It's my job to tell the best story that compels jurors to act on my client's behalf. And I think the best way to do that is to just bad guys versus good guys is a very tried and true method that everybody can understand. So
So, what's the difference between a settlement mill and what you do, and why does that matter? So,
yeah.
I'll let you go off
Well,
there.
I mean, settlement mills, they kind of speak for themselves, very high volume, lots of advertised loan, lots of case managers and paralegals, people who do the grunt work. Some trials, of course, but less than, something like a niche boutique practice like mine, where we're exclusively litigating. Um, find a lot of litigators who have sort of like trial relationships with settlement mills. So when there's a good case, but it can't be settled, then somebody like me comes in and we share fees and we work the case up for trial. I like that relationship a lot, gives me a lot of freedom. Sometimes that turns into trial consulting, which is why I sort of, joined a trial consulting group and I brushed up on a lot of my psychology training from college and things like that to try to learn and be beneficial in that space too. But settlement mills are not looking to litigate. They're looking for high volume. They're generating a lot of money from processing a lot of cases as quick as they can. Not saying that those results aren't fair for the people. Ultimately, it's the client's decision whether they take a settlement or not. I believe that that's happening at almost every settlement mill firm. It's still the clients who get to decide. But what I'm doing, an exclusive litigation firm, something different from that, I think is just looking for different types of cases, ones that have disputed liability, disputed causation issues, higher damage value, the ones that need investment. You can't take a deposition on video these days for less than $3,000. So where's that money going to come from? And so I chose a different route in my practice at a very key moment when I had some very big home runs, so to speak. I could have gone into the higher volume people and play that route, but the overhead for me was just so attractive. And then at the same time, having 100 cases, 200 cases, I wasn't able to touch every file. I just physically couldn't. I didn't understand the stories. There were too many stories. So I felt this pull to I was not becoming a storyteller. I was becoming a administrative bureaucratic paper pusher. I wasn't really working cases up for trial. I was trying to get them into settlement position. And then we're going to tell the client, and you should, because trial is really risky. And then, they're going to do what you said most of the time. They're trusting you. So you got a lot of power
Mm-hmm.
being
Mm-hmm.
their counsel. And that didn't feel good to me. Just didn't come naturally. Maybe it's my Marine or Eagle Scout spirit. I was interested in doing something more challenging than just administrating claims. And in fact, now that I'm here at this part of my career, having tried a dozen jury trials and been trial consultant on an 8-figure verdict, and I've created a software tool for people to use that can help them with smaller, lower value cases that you shouldn't need a lawyer for. It is a bureaucratic problem. It's an administrative problem. And, that to me, I didn't want to be involved in work, not trying to knock it or anything. It's just a different business model. Yeah.
So, so, so talk about I didn't, the software thing. I don't even have it on my research. So, what's tell me the story behind that.
So last year, a former client contacted me with a second round, basically. But this one was small and kind of minor, and she didn't know whether or not the insurance company was being fair. She had, of course, tried to handle it herself, and they were saying, "We're going to pay your medical bills, then we'll give you $1,500 for your pain and suffering," some kind of traditional, you know, lower level adjuster authorization.
Mm-hmm.
So she calls me asking about it, and I said, you really can't take them on yourself. You don't know what they know. I mean, you don't know even what to ask for. You don't even know how much insurance the other side has. They don't have to tell you unless you send them this letter that has this language in it. So it got me interested in maybe seeing if there was another crack at, like, things that LegalZoom and TurboTax type stuff tried to do, where you can provide people with documents that they need to send to the insurance company to sell their case themselves. But
Mm-hmm.
then I realized that this was now late summer 2025. ChatGPT, Claude, all these different coding chatbot solutions were out, and I'd never been a computer guy by any means, but I am a builder. I mean, I really like to build things and do a lot of DIY projects at home and stuff. So I was like, maybe I can build software, you know? So I started playing around with the coding platforms. I took a class on Python, which is a coding language, in my spare time. I learned a good bit from that. And then I got to an engineer and I was like, hey, can we build something that can, like, a client who's been in a small car wreck, they can upload their police report, upload their medical records and medical bills. It's all secure and private, and they can use a tool on this platform where they can put in things that are related to pain and suffering, like activities of daily living that were affected. Can we just populate a list and they can choose? Or if the diagnosis codes can be extracted from their medical records, can we count up how many different things they were diagnosed with and make that a number? And it turns out, yeah, you can do a lot of that. You can really make a software program that takes what I've done in a trial to explain how to value pain and suffering and put that into a usable tool that someone can then choose based on real factual data, a value range of what their pain and suffering portion of their case might be worth. And that, I think, has been one of the most elusive issues within personal injury is, what is pain worth? That's
So
different
let
for
me dig in a
everybody.
little bit on that topic
Yeah.
on the software topics, because so if somebody goes and so is this software been developed or is it still in the works?
It's in development right now. I actually just got a partnership agreement, investor agreement, with a whole suite of engineers. So it's
Mm-hmm.
not just my friend anymore and me. 8 weeks will be the beta launch, and but right now we currently have a website. You can go learn about it. You can We're in our testing phase. We can upload documents, generate some extracted
You got to
information and
plug the
things. So
website, Kyle. You got to
it's
plug the
well,
website.
it's mysmartsettlement.com. You can learn about, kind of what is going to be happening. It's going to be in Georgia at first because I know that law the best, but this is not a legal tool or an insurance adjusting tool. This is a self-help document generation process that just has some smart, uh, industry experience driven, uh, rule making built within inside it that I feel like is just so needed right now. But yeah, we're building it, and we're gonna start by giving people this option to say, hey, if your case is worth, say, like less than $15,000 and you don't want to have to go pay a third of that to a lawyer, if you just knew what to ask for and you just could reasonably value your case instead of just coming out of nowhere and saying, oh, well, I got 10,000 in medical bills, so let me times that by 3 and that's what I'll ask for. That model is over. That used to be the way in the 80s, 90s, 2000s. That's the way some of my mentors said it was the
Hmm.
way it went. I've even said this in front of a jury. I've said, hey, I don't know how to tell you how to value pain and suffering, but people told me growing up in the business that you just multiply the medical bills times 2 or 3, and that's fair. But that just doesn't seem it that to me is not like the best we can do in the industry of insurance and law. And when you really boil it down, when you watch a civil jury trial and you see how pain and suffering is put up, there is a calculation process. And so what I've done is I put that into a tool that you can transparently see why someone's asking for what they're asking for. And if it doesn't work, no harm, no foul. You can go get a lawyer, but if you get it to a point where you can settle your case yourself, here's one thing I know for sure, that an insurance company adjuster who has an unrepresented claimant that they have to deal with is going to love you if you show up with all the documents that a lawyer would have prepared for you, but without all the BS that some of those lawyers put on their plate. They'll wait 2 years to ask for a settlement. They'll come up with some astronomical number for pain and suffering, but they've never been on any pleadings or any court filings. So they're never actually going to show up. They're just blowing smoke. They've never actually showed up to try a case. A lot of the settlement mills we're talking about, that's their MO. They just threaten, threaten, threaten. But then when it comes time to actually file and step in a courtroom, here comes Kyle, or someone else, you know. Adjusters know this. So I think adjusters want organized, knowledgeable, unrepresented claimants, not so they can keep taking advantage of them, but so that they can unlock the authority to open up the money that the lawyers' paralegals or the lawyers' case managers have been plugging in because they know. I explain it to clients like we're holding knowledge hostage for money, you know?
So that's an interesting, so mysmartsettlement.com, and you're thinking in the next 8 weeks. So that means 12 weeks because I haven't been in software development or maybe 16 weeks, but you could
Yeah.
be
Well,
hopeful. I mean, possibly, maybe.
yeah. I mean, if anything, it's a place that my clients can go. If I get calls, people's case too small, but I wouldn't
Yeah.
advise to go try to just willy nilly on your own, just take whatever the adjuster offers you. Like, it's really going to be a process to refine over time. And it's not something I can just go, oh, well, this is how you write a demand, but there is a lot to be desired from the personal injury claim process that falls somewhere between hiring a lawyer or going it alone. There's a
Hmm.
lot of
Hmm.
innovation in insurance right now, but so much of it is focused on helping insurers and their workflow, helping law firms and their people, but nobody, at least, hasn't really tried to like seriously target the people who are buying the product. When you buy an insurance policy, your thought process is, if I have a claim one day, it starts there. Claims is what's being sold, but claims is the afterthought. Claims is the last place to innovate. Why? You know, it's, I'm trying to just create something that's an alternative to that, but I'm not going to stop doing personal injury cases or vaccine cases. But I
So
like to
let's
work
talk.
on
I want to
cases.
talk
Yeah.
about two other things because we only have a limited amount of time. One is I want to talk about your trial consulting, and then about your vaccine cases.
Yeah.
So you're one of a handful, what, a couple hundred people in the U.S. that
I
can
mean,
prosecute.
it's yeah, it's probably bigger now, but it's really small. And when I first started, it was really small. It was only 2 people in Georgia. I had to trap one down to be admitted. They had to sign a paper to help me get admitted to the court. I think after COVID, the cultural perception of vaccinations changed for better, for worse, but it brought more light to the topic. And so there's more people doing it now. But yeah, I've handled several cases for people who were legitimately hurt by vaccinations. I've had neurologists and other medical experts testify to causation, and it has resulted in significant money for my clients. There's some caps on the compensation people can get in the vaccine program, but it generally can provide some relief for people financially who otherwise wouldn't have any place to go because of the various immunities and protections that vaccine manufacturers and administrators, physicians, nurses, um, pharmacists. You can get a vaccine at a Kroger
Right.
pharmacy when you're in the checkout
I didn't know
line.
there was anything you could do with the vaccines. I thought they had total immunity.
They don't. They did for various emergency use authorizations and COVID related things. There was another system in place to compensate people for claims that happened from COVID vaccinations. It has a lot of shortcomings. Some lawyers have really championed this effort. There's some good folks in Florida that I've referred some cases to that exclusively, 20, 30 lawyers work on only vaccine cases. The great thing about working on the vaccine cases is that you can take cases from any state. It's a multi-jurisdictional practice. So if someone calls me from Washington and says, "Hey, I heard about you. I want to use you," I can do that. I'm not limited to Georgia. So, but I will say it's not, something that I make a lot of money from. Just
Mhm.
for the business listeners out there, the government pays my fees. They pay a reasonable fair market rate. They don't pay me my full rate for things that I do that might be paralegal tasks. They pay me what a paralegal would make, even though I don't have any paralegals. So they kind of nickel and dime me a little bit. But at the end of the day, it feels really good to help someone who didn't have any idea that they could be hurt by something like this, then to be validated, then to be compensated. It's a real feel good, situation as a lawyer who wants to help people. So
So
I do
talk
it for
about
them.
your consulting. So tell me about your consulting.
Yeah, so I decided to and branch out a little more into consulting after working on a very significant case in North Georgia for one of my mentors and great friends, Shane Lazenby. He had a trucking wreck case where a pedestrian was killed, and he did a fantastic job trying that case. It was one of the top 50 verdicts in America in 2020 for a trucking case, and a very rural conservative venue in North Georgia. Part of working with Shane on that case was just, honestly being a friend to him and listening to, his thoughts about the case and offering feedback. And my wife, candidly, and I have pretty much come up with every theme for every one of my trials together. She's a photographer and artist like you, so she's got a different eye. And I believe that she's an inspiration for approaching trials the way we did with Shane's case. That we really just tried to develop a theme based on a fact in the case that would really trigger that motivation to act that we want from jurors. It's really easy to get lost in the mundane and the boring of a trial. And so my trial consulting is an amalgamation of various trainings and experiences I've had in my life that really boil down to presenting, conducting, and isolating to touchstones of a story, 3 to 5 good facts, bad facts, whatever those are, to get your point across and to limit as much as possible the amount of time that's spent on trying to prove a point or be right, and just finding that thing that really just hooks, just like a song gets stuck in your head. And so we developed just a small little theme in that case based on one of the facts was that the truck driver had lied to his medical examiner about his health conditions, and he got a certificate to drive a truck on false pretenses, basically. So even though his certificate said that he was physically fit to drive, he wasn't physically fit to drive, and that was part of how the wreck happened, was related to his health and such. So what we said to the jurors was, when he lied to his medical examiner to get his DOT certificate, he lied to all of us on the roadways who share the roads with him. And you could just see the jurors really just gel all together with this fact that you can't say things like, put yourself in the plaintiff's shoes. That's against the evidentiary rules in Georgia. Other states have different versions, but it's the golden rule. You can't say that. It plays on sympathy and not evidence.
Mhm.
So saying something like, look at what the defendant did and how that relates to everybody in this room. It really makes it personal. It makes it a story that you can easily resonate with, and it brings the attention of who to blame to the right place. Where the defense wants to blame other things that don't relate to their client's culpability. That's their job, and they're very effective at that at high levels. Some of the best defense lawyers in the world do medical malpractice cases, and they are tight with this model of deflecting and pointing at other things, but a lie, if I can find a lie, we're going to make that a centerpiece. Like the whole story is going to revolve around a lie, because that's just so simple. I have another technique in my trial consulting. I call it the Baker principle. That's my 8-year old. He's now 9. If my 9-year old can get it, then the jurors are going to get it. If my 9-year old's upset by it, if he feels wronged by it, then it's going to cut to some real deep chord, some visceral chord. And I think there might be some people who call this Reptile. There's some other books out there about preying on fears and various things. I've never read those books, but I think it's just a general human philosophy that if you are tapping into fear, then you're motivating to act. And
Mhm.
that's really the trick to the trial consulting, is to work with people in their cases, witnesses, lawyers, whoever, and discover those touchstone facts that can be weaved into a story that ultimately compels people to act. Like you can't not do something about this without violating all these little rules and different tricks and all. I'm not, saying that I'm the best at making objections or the smartest guy in the room and I didn't go to Harvard. But I can tell you that none of that really matters to lay jurors who ultimately make the decision of what the truth is in a case. You can jump up and down all you want about not being liable, but at the end of the day, if it looks and smells like you're liable, it's probably going to end up that way, despite your bias,
Well,
because
Kyle, I
obviously
think we're gonna wind it up here. Except I want to find out. So if somebody says, "Oh, I like that, Kyle. I've either had a car accident, a truck accident, or I'm another lawyer and I want some help with this idea of telling a story at trial because that is a big difference maker." What's the best way to get in touch with you?
you can call me. I still talk on the phone to people all the time. So you can call me 678-316-7318. You can go to my website, morelaw.com. Um, that's pretty much the only ways. Email me from the website, but that, call anytime. I'll never not take somebody's call. That's the fortunate thing I have about being a small boutique. I can just kind of do what I want, come and go as I please. So I'm happy to talk to anybody who's curious about how to make more from what they have. And that's, kind of built myself was I took trash and turned it into treasure. And I did the same thing with the news. I was going to go invade Iraq. I'm like, we'll make something of this if I make it out here.
Kyle, thanks a lot for coming on. I really enjoyed it.
I appreciate it. Thank you, Zane. Thanks so much, man. Let me know if I can help you in any way.